Attorney Lichten.
Good morning. May it please the Court. My name is Harold Lichten. With me is Steve Churchill, and we're honored to represent the plaintiffs in this case. This is a problem that has been going on for 40 years, a problem which you yourself have recognized in a number of cases, Aubin case, Brackett versus Civil Service Commission, and in other cases. The problem is that for more than 40 years, the Commonwealth of Massachusetts, both for entry-level police and firefighters and for superior police officers and firefighters, has created, devised, scored, ranked, and administered an exam that has a huge, disproportionate, discriminatory impact on minorities and cannot be shown by any acceptable and legal method to be valid under applicable state and federal guidelines.
Mr. Lichten, let me ask you this, though. Given what you say, or assuming that's correct and you allege that the Commonwealth has played a, quote, active, knowing, and central role in longstanding exclusion of black and Hispanic candidates, I guess I'm wondering whether, at what point does disparate impact turn into intentional discrimination? I mean, and are you alleging in some way disparate treatment?
Yes, that's a good point, Your Honor. In fact, the complaint that we filed can be read to say that the Commonwealth has known for so long that this has been going on that it constitutes a form of disparate treatment as well as disparate impact discrimination. In a supplement, an addendum to the brief filed by the MCAD last week, they attached a
that
decision.
brief has been withdrawn.
It's been moved to be withdrawn. We're opposing that, Your Honor. And there's been no, it's still on the docket as of this morning. In any event, there was an attachment to that brief out of Worcester in which just that very fact, the city's refusal to, time and time again, to request a special list for minorities constituted, in their opinion, disparate treatment. So I think, although this case is primarily a disparate impact case, I think you could argue that it rises to the level of disparate treatment given the 40 years of inactivity and the knowing result that by giving this exam, it will have the effect of discriminating against minority police officers.
So what's the remedy? Let's assume we agree with the Attorney General's office that the state has not waived sovereign immunity and that the state is not the employer and whatever. What would the remedy be?
Sure. Putting aside the issue of damages, the primary remedy is to create an examination system that doesn't have this significant disparate impact. And since we've tried for 18 days the companion case involving the municipalities, we've had experts testify exactly what that is, and it's very simple. When you're testing for what makes a good police superior officer, what you need to test for is situational judgment, the ability to make decisions, involvement with the community. But the test that they currently have is a multiple choice, 100-question test that only tests the ability to memorize out of text certain answers. That's all it does.
And that test has been challenged.
That test has been challenged.
And why aren't those and how has that test been challenged?
Okay, so when the First Circuit in the Lopez case in federal court decided that the state could not be held as an employer under Title VII with very different statutory provisions than the ones at issue here, the First Circuit did permit the case against the 11 or 12 municipalities to go to trial. Mm-hmm. Now, as we point out in our addendums, the cities are arguing, how can you hold us liable for an exam system that the state is responsible for and that they create? The court nevertheless permitted the case to go to trial. That's one of the defenses the cities have utilized, and we're waiting for a decision. We've been waiting for a decision for about 15 months. But the problem, the core of the problem, lies with the state-administered examination. And another problem raised by that examination is the problem of statistical significance. Now, although it hasn't been decided yet, if you look at every city, let's say Lowell, you look at Lawrence, you look at Springfield, in any given year or for any given exam, there only may be 3 or 4 or 5 promotions to sergeant or lieutenant or captain, if that. Well, you could have severe discriminatory impact, that is, every year no minorities get promoted. But if you're only looking at that particular city, you don't have what statisticians call statistical significant discrimination, and therefore you lose, because the problem is, if you look at the statewide exam and how promotions are made in rank order statewide, then you can see the patterns, and this is what our experts have said, of severe discrimination.
How heavily weighted is the exam itself in the decision to
It's everything.
appoint something?
It's everything.
It's 100%?
You get, it's 80% of the exam score, then you get several points for training and experience, and everybody gets 14 points for training and experience just by being in this next level, police officer or sergeant, for 3 years. You get 14 points for that. And so the exam counts for approximately, statistically speaking, about 95% of the exam score.
I thought that cities and towns could decide how much weight to give the exam.
Oh, no. What they can do is, what the only option they have is, once they get the scores back from the state and they rank everybody in the order of their exam score, they can then pick among the top 3. So let's say they have 5 openings. They can then call for, that's under the 2N+1 rule, they can get 11, the first 11 names, and they have to pick from among that. But what the evidence at trial, and the trial we did, showed that virtually all cities just promote right from the top of the list. And even if they don't, if they skip down 2 or 3, you're still not addressing the problem, because you still have bunched together at the top non-minority officers. Then you have minority officers with good scores, but not good enough to get in the ranks where they're actually going to be promoted.
Is the use of the Division of Human Resources test required?
No. So look, one of the arguments the defendants is making, and it is an argument, is that, look, a municipality could devise and create their own test. But the municipalities, particularly in this budget era, are saying there's no way we can spend the hundreds of thousands of dollars to hire the experts and PhDs and statisticians you need to create these job-related valid tests, particularly in the cities, unlike Boston, that may have even less financial resources. That's what their argument has been. While the evidence has shown that a very few communities over the last 20 years have used these alternative promotional exams, literally 95% of all the civil service communities use this statewide exam, and the statute calls for permitting them to use this statewide exam.
I take it that your argument isn't that, well, if you just created different questions,
No.
it would work. You're saying, no, this whole structure is flawed. It can't be a written exam.
There is not one city in the United States of any size that continues to use, for promoting to police superior officer, a multiple choice written question that requires rote memory. All of them have multiple exercises, some of which involve assessment centers, some that detect situational judgment ability, some which are structured oral interviews, all of which will have a written component to show basic understanding. And all of my clients have shown that basic understanding by scoring in the 70s or 80s on their test, but will go on to test for the factors that really get at who is a good police supervisor, and that's someone who has this judgment, who's been in the community, not someone who can sit and memorize a test.
So if the test were to have a weighted score in the ultimate decision of, say, 20 or 25%, that would satisfy your requirements?
Absolutely, and that's what our experts have said, that there has to be a system that does not have this severe disparate impact upon minority officers. I would just point out, and I do want to get to my argument, that the problem is so bad, and we've shown you this in our record at page 76, that there are many large cities who have virtually no minority police officers. The record that we presented to you shows that Lawrence has only 1 minority police sergeant, Brockton has 0, Worcester has 3 out of 99, Quincy has 0, Lynn has 1.
So why aren't they, so you sue them. Say,
We
hey,
sued them, that's
sue them.
correct. And they're all arguing, number one, you don't have statistical significance except for Boston, because you can't.
How is it not statistically significant that a community like Lawrence has, you said, 1 minority?
Because they're saying that if you go from exam to exam and there are only 3 people, and just 1 promotion of minority would skew the results, and therefore it doesn't achieve statistical significance.
But the communities choose to use that exam, as Justice Spina was saying, they can do other things. So they've chosen to use an exam, and the result has been they have no minority police officers.
They are using that exam, as are 95% of all the civil service communities, including Boston, Springfield, Worcester, the MBTA. They're all using it, and the same effect has occurred
But you don't
universally.
have to, you can use the exam, but you don't have to take the people like in the order of
You
1,
have
2,
to
3,
follow
4,
the
5.
2n+1 formula. You may not deviate from that. You can pick among
So
the
you get
top
the
three.
top 11 if you've got two
Yes.
seats.
If you have
as were
5
saying
openings,
before.
you could pick among the top
All
11.
right, so let's get to the problem. We
Thank
understand
you.
the environment, which you've done a very good job of setting out here, but the Commonwealth is not the employer,
That's correct.
number one.
And
Go ahead. And 151B is really directed at employers.
Well, on that point, I would disagree. I would say that prior to the Lopez decision in the First Circuit, it was an open question in many federal courts around the country, and still is, as to whether when a state has a significant involvement and control over an aspect of an employment decision, an actual employment decision, they could be held liable under Title VII, which has none of the expansive language involving persons, aiding, abetting, or interference that Chapter 151B did. In 2006, Judge Saris, in a case we've cited to you, held that the state was an employer for purposes of its discriminatory entry-level firefighter exam and held them liable to Title VII. The state did not appeal that. The First Circuit disagreed. The First Circuit said that because of the language in Title VII, which only permits a lawsuit against an employer, not a person, and has no aiding and abetting or interference language, they held that while they recognized that other circuits had gone the other way and allowed Title VII to be used to catch interfering with employment relations when it was discriminatory, they found that the language of Title VII did not permit that construction.
I'm sorry, finish.
Sure. But that is so far different from what Chapter 151B states, because Chapter 151B in 3 important ways differs from Title VII. First, it says that any person, unlike Title VII, may be held liable for discrimination, and it defines person as the Commonwealth.
4.1 is employer,
What?
correct? 4.1 is employer.
4.1 is employer.
So you're not talking about that?
Well, I'm suggesting that Justice Saris is still right, and that you have the right to disagree with the First Circuit.
Okay, but when you're focusing on person, you're really talking about 4.4A
That's
and
correct.
4.5, right?
That's correct. But the Commonwealth is also defined as an employer and is an employer under Section 4 also. All I'm saying is that I think Justice Saris may have been correct with respect to the first issue as to whether you could hold them liable under Section 4. You have on a number of occasions decided that when the feds go in a way that you think is wrong, you will go another way. You did
You
that.
mean 4.1, because this is all
4.1,
4.
yes. In the Gilbert case, you found that pregnancy was sex discrimination. You disagreed with the U.S. Supreme Court. Congress agreed and amended the law. In the Dayhill case, you found that you look at the question of disability without regard to mitigating measures. The U.S. Supreme Court disagreed. Congress finally agreed with you and changed the law. So you would have the right to say, we disagree with the First Circuit's decision in Lopez, and that when an entity like the Commonwealth has so much control over a particular aspect of a hiring decision, in this case promotions, then they can be held to be an employer under Title VII. But you don't need to say that, because you can also then go to the aiding and abetting language and the interference language, and there I think it's an open and shut case. By its very terms, our statute says that any person who either interferes with someone's right to be free of discrimination or anyone who aids and abets another in the act of discrimination can be held liable. Now, what I think is very interesting, if I might.
Let me ask you as to how far that goes. I mean, let's assume that the cities say we're going to drop the state test, we're going to use the SATs, which is going to use the SAT scores, and then it turns out that the SAT scores have a similar disparate impact. Can you sue the Princeton Review for interfering and aiding and abetting?
It's ETS, not
ETS, sorry.
Just are you saying that that test is used for
Police, right? Let's assume the police say
purposes?
yes. Let's assume
Yes.
that they drop this written test and they say let's use the SAT. It's a test that's been widely used. We'll use that test. We'll use that as our.
I don't think you need to get that far, but if in fact the SATs knew that it was being used for that purpose, were marketing for that purpose, and knew that it had this discriminatory effect year after year, I think the answer may be yes to that.
Would you
Go ahead.
For purposes of looking at the person part of the aiding and abetting and interfering, are you suggesting that we should read your complaint as limited to disparate impact, or should we be reading it more broadly to include
I think you
the
should read it
potential
both ways. My primary argument is that it includes disparate impact primarily. But I think you can also read it as including disparate treatment. I think in both respects, you still get at the same result, that is, the Commonwealth can be held liable. And furthermore, I think it would be unfortunate if you only held that it reaches disparate treatment, because then the ability to get at the exam in the manner it should be by proving its disparate impact and how it should be made job-related, all a process utilized under disparate impact, might not occur. The final thing I want to say, if I can just say one more thing, I'm destined to get this out. If you read the Ninth Circuit decision in Mexican-American Educators and the Seventh Circuit decision in EEOC Illinois, and I want to tell you why they're very important. The First Circuit said in their Lopez decision, we're not going to follow the law of other circuits that have recognized this doctrine as employment. And the First Circuit said, we're not doing that because the language doesn't lend itself. In the Ninth Circuit, the court found that when the state developed and scored and ranked a test for teachers, that did lend itself to Title VII liability. But if you read the dissents, so the dissents would have agreed with the First Circuit that Title VII cannot be used to reach state exams, it's really important to listen to what the Ninth Circuit dissenters said. They say, they recognize that in a line of cases beginning with Shibley, many courts, including this one, have extended Title VII liability to employers who discriminatorily interfere with an individual's employment relationship with a third party. But to extend Title VII's reach in this way requires not only an unnatural reading of the statute, but also a dubious inference. If Congress had intended to create liability for interference with third-party employment relationships, they would have done so. But that's exactly what the Massachusetts legislature did here. And that's why even the dissenters would have agreed that given that the legislature, in its wisdom, put in Chapter 151B a provision that made it unlawful for a person, i.e. the Commonwealth, to interfere with someone's enjoyment of the right to be free from discrimination in the workplace, means that you should do the same.
Mr. Lichten, can the 2N+1 formula be trumped by a collective bargaining agreement?
No, absolutely not.
Okay. All right, thank you.
Thank you, Your Honors.
Attorney Shin?
Good morning, Your Honors. May it please the Court. I just want to note at the outset two things that are not at issue in this case. First, not at issue is whether plaintiffs have a remedy if HRD intentionally designs and administers a discriminatory exam. In cases of intentional discrimination, plaintiffs absolutely should have a remedy, and they do. They can file a Section 1983 action claiming a direct violation of their rights under the Equal Protection Clause. The second thing that is not at issue is whether the plaintiffs have a remedy if they believe that an exam does not fairly test for the abilities to be a good police sergeant. In that instance, in addition to any claims they might have against their employers, the legislature has expressly provided a remedy in Chapter 31. Under Sections 22 to 24, applicants have the right to request that HRD review a test to determine whether it was fair, and that determination can then be appealed to the Civil Service Commission, followed by the Superior Court.
Has anybody ever done that?
They have, Your Honor. There's the Boston Police line of cases that's cited in my brief, and that case actually did result in a published decision in the appeals court, and that citation is 35 Mass App Court 688. It's a 1993 decision. So the only real issue presented in this case is whether Chapter 151B authorizes the plaintiffs to pursue damages and attorney's fees against the Commonwealth and put it through the burdens of a trial when the Commonwealth is undisputedly not their employer and did not act with any intent to discriminate or to harm the plaintiffs in any way.
Well, that's, I mean, as I've said to Mr. Lichten, it seems to me the complaint can be read to suggest that there was an intent to discriminate because knowledge for 40 years and doing nothing equals intent. I mean, that's the implication.
First of all, Your Honor, that is not a fair reading of the complaint. I would direct the court to the record at 411 and 417, which clearly says that this case is based on a disparate impact theory, and that is also alleged in the opening brief. And moreover, Your Honor, the plaintiff's argument that this case is somehow unique because HRD had knowledge about disparate impact and invalidity, that does not make this case unique, because we generally as a society know that certain exams will have a disparate impact on certain groups. We know that when HRD administers a physical abilities test, that women as a group will usually, if not always, do worse than men. And plaintiffs point out the testing experts' amicus brief in the Ricci case in the Supreme Court, and those testing experts say that all written standardized tests will result in a disparate impact on certain minority groups. So what plaintiffs say is a limiting principle really is not a limiting principle at all, because it could be overcome in every case with a bare allegation that the agency was aware that the exam would have a disparate impact, and then in every case the Commonwealth would be forced to go through the burdens of trial in order to defend the validity of its exam.
So what is the answer to the problem? Are you suggesting there's no problem, or there's simply no answer?
The answer, Your Honor, is if it's not a fair test for the abilities for the position, then the remedy is the fair test appeal procedures that's provided in Chapter 31. I just want to emphasize that disparate impact alone does not make an exam unlawful. The employer can always defend its selection procedure by showing that the exam is a valid predictor of job performance.
Haven't your own consultants indicated that there's an issue with how you score these? The
Our own
tests,
consultants, Your
with
Honor?
like bands of scores that should be looked at?
Our own consultants, Your Honor? No. We submitted, before we were dismissed from the federal case, we submitted expert reports defending the validity of these exams.
Even with the scoring the way that it is?
Yes, Your Honor, and that issue has not been decided in the federal case as of yet. Yes, Your Honor.
Under the fair test appeal procedure which you describe, can disparate impact be a basis for having the exam thrown out?
No, Your Honor, and again, disparate impact alone does not make an exam unlawful, and I would actually direct
So how is that a remedy?
Excuse me, Your Honor?
How is that a remedy? Justice Gaines's question.
Because even in a claim for disparate impact under Title VII or 151B, the plaintiff cannot prevail simply by showing disparate impact, because again, the employer always has the defense that the exam, even though it results in disparate impact, is a valid predictor of job performance. And I would direct the court to the Supreme Court's decision in the Ricci case from 3 years ago.
So let us imagine a test which has a disparate impact
Yes.
against minorities and is not a valid predictor of job success, which I think is the claim here. If you go through the fair test appeal procedure, and if you prove that, do you win?
If you prove that the test is not a valid test, then yes, you would win under the fair test appeal procedures, regardless of disparate impact.
When you say a valid test, I'm not quite sure what that means.
That it is a fair predictor for your ability to be a good police sergeant, or whatever position that the test is testing for.
And does disparate impact play any role in that?
It doesn't. So a fair test appeal procedure could actually be brought by anybody. In a disparate impact analysis, if the plaintiffs first have the burden to show that a test has a disparate impact on a certain protected group, that's just the prima facie burden. After that, the burden will shift to the defendant to show that its selection procedure was job-related and valid, and that would satisfy the defendant's burden. So the point I'm trying to make is that disparate impact alone does not make a test
When you say
unlawful.
job-related, let's give the worst possible example. You have a test in which no African-American has ever passed. And the other side can prove that there are other tests which are more valid for which African Americans would do just fine. Will that test survive the validity test for the fair test appeal procedure?
If it's not say, for instance, HRD were to give the SATs, it would not satisfy. It would not pass the fair test appeal procedures. The Civil Service Commission in that instance would have the equitable authority to order a new examination, as they did in the Boston police line of cases. And I want to point the court to the Ricci decision, because despite what the testing experts said in that case, the actual holding of the Supreme Court was that despite the amicus brief, all the evidence in that case showed that the written test was in fact valid, despite the fact that it resulted in very significant adverse impact on minorities. And also, Your Honors, as a pleading matter, I would ask the court to reject the plaintiff's bare assertion that HRD has known for decades that this exam is discriminatory and invalid. Although the court must accept the allegations of the complaint as true, plaintiffs still have to plead enough facts under Iannuccino to show a plausible entitlement to relief. All we have in the complaint is a bare allegation that HRD has known for 20 years that this exam has an adverse impact and isn't job-related. In their brief, they expand on that, and they say we've known for 40 years. And in their reply brief, they say, oh, for over 40 years. So where are they getting the 40 years? They are getting it from the entry-level firefighter exam that the Commonwealth gave in the 1970s that was the subject of the Beecher line of cases. And if you read the First Circuit's decision in Beecher, which is cited in the plaintiff's brief, back in the 1970s, the Commonwealth was testing for things that clearly had no relation to someone's ability to be a good firefighter. They were testing for knowledge of current events, spelling, vocabulary, and arithmetic. The sergeant exams that HRD has given in recent years test for knowledge of things contained in the police manuals, knowledge of rules and regulations, knowledge of general laws, things that are all related to the duties of being a police sergeant.
Could you tell the Ricci case? What case? Give me the site on that case.
It's 129 Supreme Court, 2658.
Thank you, Your Honor. So the statement in the plaintiff's reply brief that the Commonwealth has been giving the same test for 40 years, for over 40 years, is misleading and inaccurate. Not every pen and paper test is the same, and not every pen and paper test is invalid, as shown by Ricci. And before HRD was dismissed from the federal lawsuit, HRD did submit expert reports defending the validity of its exam. So there's nothing peculiar in this case in terms of HRD's knowledge that would make it appropriate to apply 151B here, but not to other potential future challenges to the various licensing and certification exams that the Commonwealth gives every year. And although the plaintiffs say that they're not challenging licensing or certification exams, they don't explain why this case would be any different. And their theory would absolutely extend to each one of those exams.
Let me ask you this. Knowing, as I take it, you concede HRD knows that these tests end up having a disparate impact, what is HRD doing about that, if anything? Or what is it obligated to do about it?
It's obligated under Chapter 31 to make sure that the test validly predicts the abilities to be a good police sergeant. And again, if HRD does not meet that obligation, that can be challenged.
There may be several different types of tests that validly predict, but if this particular test, I mean, there could be several different types that validly
Certainly,
predict,
Your Honor.
right?
Yes.
Some of which might have a more severe, desperate impact than others. Isn't
That's-
there some obligation to sort of take that into account and try to find a test that is both valid and doesn't have such an impact?
No, Your Honor. The Commonwealth's HRD's obligation would be to make sure that it is a valid predictor of job performance. That would be its obligation under Chapter 31.
So we have to accept as that valid that Brockton has 0 minority superior officers? I mean, there's just something that seems not right about this.
I'm not asking the court to accept that the test was valid. I'm saying that if the Commonwealth doesn't meet its obligation to make the test valid, then that could be challenged through Chapter 31. And I also want to point out that the test is not, by far, not the only determinant of who gets promoted. The municipalities can consider all sorts of other things, such as the interview, the job performance, disciplinary history, education, specialized skills.
And they can weight that. They can weight the test at 25%.
They can't weight it differently unless they've entered into a delegation agreement with HRD. But what they can do is bypass people who are, for instance, if the municipality believes that candidate number 3 has better job performance than candidate number 1, then it can bypass candidate number 1.
But if there's no one in that top 3 who's a minority, that's a meaningless statement.
They would have to choose within the 2N plus 1 group.
They're bound to do that. And so if you don't have any minority applicants who have scored in that range, what are we talking about?
That much is true, Your Honor, but again, the municipalities are authorized to use their own promotional exams.
So that's really the only option they have. They can use their own test. But if they opt to use the state test,
Then they would be bound by the 2N+1. But
Right.
what certain municipalities have done is they've used the state test, and then they've added components to the state test. So they've added assessment centers.
If
But they
every
never get
patrol-
beyond the- I'm sorry.
If every patrol officer in, say, the city of Lynn took the exam, even though they never expected or never intended to become a sergeant, along with the 2 or 3 or 4 others that might actually be genuinely interested in becoming sergeant, if every police officer in the town of Lynn took the police exam, would that increase the 2N+1 scope to a much larger number?
The N in that formula, Your
Oh.
Honor, is how many positions the city is trying to fill.
Oh, all right, okay. Okay.
I did want to address one case that the plaintiff brought up today and is also discussed for the first time in the reply brief, and that is EEOC versus Illinois. In that case, the Seventh Circuit did not find that you can apply the interference theory against a state. In fact, what the court said was that it was, quote, doubtful and implausible that Congress intended to create interference liability. What it did recognize is that there is room for a de facto theory, which is a completely different theory from the interference theory. And as the court explained in the Lopez case, it's actually the same as the common law agency test. Yes, Your Honor.
I'm sorry, because I haven't read it, but when you say it can't apply it against the state, is that because of the 11th Amendment? I mean, is that because it's federal court that's talking, or is it an 11th Amendment issue or something else?
The court said that it could be an 11th Amendment issue, but it wasn't so limited. But that is significant, Your Honor, because other than the AMAE case, every federal court of appeals has held that you cannot apply the interference theory against the state, and that is because, like the sovereign immunity analysis that this court has adopted, the federal courts require a clear statement of congressional intent in order to waive 11th Amendment immunity.
Let me turn to that. When you have a statute, as 151B does, that goes out of its way to include the Commonwealth in both the definition of employer and of person, you're saying the court should say, well, yes, but we get to read into that this theory but not that theory? I just don't understand why you get to pick and choose what, once you're in there, why you get to pick and choose what theories may subject the state to liability or not.
That's not what I'm saying, Your Honor. First of all, this court has consistently held for 30 years that subsection 1 applies to employers, so that is irrespective of the sovereign immunity issue. Since Commonwealth is not the employer, it cannot be held
But
liable
you seem
under
to be
subsection
arguing
1.
that it's not the employer and sovereign immunity would prevent it from being reached, and I took that to be something different than it's not the employer.
My argument under subsection 1 is that it is immune because it is not the employer. But my arguments under subsection 4A and 5 are not that those subsections require an employment relationship. It clearly reaches persons and not employer. My argument there is that the language of the statute doesn't clearly extend to an agency that is discharging a government function pursuant to a statutory mandate that's contained in a separate section of the general laws, because Chapter 31 requires that HRD administer these exams for appointments within the civil service system. And even if this court were to hold that your ruling, if you adopt the plaintiff's position, wouldn't extend to certification exams, which it would, and in fact plaintiffs rely on AMEE, which involved a challenge to a teacher certification exam. Even if the court were to say that this case is distinguishable, I would ask the court to consider HRD alone. By its mandate, and under Chapter 31, it is required to give multiple exams every year. In any given year, it could give multiple exams for police, not just for sergeants, but from entry-level sergeants, going all the way up through chief. It gives multiple exams for firefighters from entry level all the way up through chief, and for other civil service positions such as correctional officers. And while it has the obligation to make the test fair, there is unfortunately no such thing as a fair test that does not result in adverse impact on some group. In the Bradley case, the minority plaintiffs claimed that a firefighter exam that does not include a physical component is not fair and has a disparate impact on minorities. But as the court can see from the recent 16L submission that plaintiff filed, if there is a physical component, then HRD is faced with claims from women claiming that the exam had a disparate impact on them. So creating the perfect test is really an illusory goal. What matters is that the test is fair.
But on that point, and I was confused by your answer to Justice Cordy, let's imagine that there is a 151B remedy, and let's assume there's proof of disparate impact, and let's assume that your test is deemed to be valid, but there's another test used in other states which is equally valid but doesn't have that disparate impact. Don't you lose under 151B?
Yes, and that would be the difference between the fair test procedures and
So in
the
a fair test
151B.
procedure, you win,
If our test is valid, yes.
and in 151B, you lose.
Yes, that's true, Your Honor. But even if plaintiffs believe that 151B should cover these claims, of course the question isn't what the plaintiffs want the statute to say, but what it does say. And the interference provision is specifically limited to acts that are similar in kind to coercion, intimidation, and threats. And in Courier, this court held that even a direct violation of someone's rights does not constitute coercion. It has to be an active domination of one's will. HRD did not require the municipalities to even use this exam.
That's your argument, that interfere, right? That it has to be like coercion.
Absolutely, Your Honor. And with respect to non-employers, the legislature has made that very clear. And under the plaintiff's rule, HRD could be sued years after the fact, after an exam is given, because the limitations period is 3 years. And they could be sued by any number of groups that say that some exam impacted them in a disparate manner. And that would be an unworkable rule, and there's no indication, let alone clear indication, that that's what the legislature intended.
Thank you.
Thank you, Your Honors.